Resuming debate, the Honourable Member for Northumberland-Quinte West.
Well, thank you, Mr. Speaker. I appreciate this opportunity to join in the debate of Bill C-5 and to outline yet another way our government is delivering on its commitment to keep our streets and communities safe. As my honourable colleagues have mentioned, our government has already done a lot of things in regard over the last 4 years. We've taken steps to ensure that violent criminals are dealt with appropriately. We've introduced legislation to ensure that serious crimes are met with serious jail times. We've given police and law enforcement officials the tools and resources they need to do their jobs. All these initiatives are vital to our work of building safer communities for everyone, as is the legislation before us today. Our government has made public safety a #1 priority since we were first elected in 2006. That is what the legislation we've introduced today is all about. Mr. Speaker, Bill C-5 will help to ensure that Canadians continue to feel safe in their homes by strengthening the International Transfer of Offenders Act. Specifically, the legislation we have introduced recognizes that considerations of public safety are the very center of decisions about whether offenders serving sentences abroad are transferred to Canada. Our government has also made sure that helping victims of crime remains at the heart of this government's public safety and justice agenda. We've committed to ensuring that their voices are heard and that their concerns are taken seriously. That is one of our highest priorities and why we've taken action on a number of fronts. The legislation our government is proposing will help further strengthen this track record by ensuring that the safety of victims can be taken into account when assessing requests for transfer. As well, the changes which our government is proposing stipulate that the safety of family members and children can be taken into account. The Minister will specifically be able to consider whether the transfer of an offender with assault convictions against family members would endanger their safety. The Minister will also be able to specifically consider whether an offender incarcerated for a sexual offence against a child in a foreign state is likely to commit a sexual offence against a child if transferred to Canada. Surely, Mr. Speaker, these changes make sense. The way things stand today, Mr. Speaker, the Minister is required by law to take several factors into account when considering a request for transfer. These include whether the offender's return to Canada would constitute a threat to the security of Canada, whether the offender left or remained outside Canada with the intention of abandoning Canada as their place of permanent residence, whether the offender has social or family ties in Canada, and whether the foreign entity or its prison system presents a serious threat to the offender's security or human rights. These are important considerations to take into account, but nowhere in the current law is there specific mention of protecting the safety and security of law-abiding Canadian citizens. Nowhere is there any specifically mention of victims, family members, or children. These are serious omissions. Mr. Speaker, the bill before us today will correct this. As well, Bill C-5 will allow the Minister to consider a number of other factors when considering offender requests for transfer. For example, the Minister will be able to consider whether an offender who requests a transfer to Canada has refused to participate in career, vocational, or educational programs while incarcerated in another country. The Minister will be able to take into account the circumstances in which the offender, if transferred to Canada, will be monitored and supervised after release. That's especially important given that one of the purposes of the Act under the amendments our government is proposing will continue to be contributing to the administration of justice and the rehabilitation of offenders and their reintegration into the community. Mr. Speaker, Bill C-5 will also allow the Minister to take into account several other very important considerations when assessing offender requests for a transfer. These are whether the offender has accepted responsibility for the offense for which they have been convicted, including acknowledging the harm done to victims and to the community, and whether the offender is likely to continue to engage in criminal activity after the transfer. Again, these considerations should surely help to guide decisions about whether to grant a request for transfer from an offender serving a sentence overseas. But at the moment, there is no clear legislative authority for the minister to take them into account. That's what Bill C-5 will change, while also providing the minister with more flexibility in decision-making itself. Mr. Speaker, the legislation which our government has introduced today is designed to keep Canadians safe. It's fair, it's timely, and it's what Canadians want. I therefore urge all members to work with this government to ensure its speedy passage. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for Bonavista, Gander, Grand Falls, Windsor.
Thank you, Mr. Speaker, and I want to commend my colleague there for his speech, and also the colleague before him who also made the speech. And I never had the opportunity to get up and ask him a question, but I'll bring it on to my colleague from Ontario. The bill itself, the C-5, talks to, from what I understand now, this is to, quote, enhance public safety, which is the major key plank of this particular legislation, which was never thought of before, as was pointed out by him. One of the things that he says was to rehabilitate, or the ability to rehabilitate as was assessed, or I think that's what he said, to assess by another country. For example, if someone is in, say, the United States right now, and there are programs available for them to rehabilitate, vocational and certain programs such as that, if that individual was unable or certainly unwilling to take steps or measures to rehabilitate, that would be used against that individual applying for the transfer into this country. Is that necessarily the case? Or but what about in countries that don't necessarily have the programs for rehabilitation? That too would be considered. And is that my understanding of it? Is that what he's pushing for? In other words, to rehabilitate someone or to gauge that person's ability to rehabilitate also depends on the system in that country.
The Honourable Member for Northumberland-Quinte West.
Well, I'd like to thank the member for a very pertinent question. Yes, in answer to his question, if the prisoner in the country concerned, if that country doesn't have a prison system which affords the ability for rehabilitation or to educate one, to further one's education, to develop skills, of course this legislation permits the minister to take that into account. It also says, quite frankly, and it was mentioned in my speech, that if the person has indicated that they were prepared to, in a country like the United States, Great Britain, Norway, and other countries who have similar correctional facilities to Canada, and I particularly refer to countries like Norway and Great Britain who have, when we visited the prisons there, said that 60% of their programs were adopted from Corrections Canada. I think it would make it very easy then for the minister to be able to make that assessment. And I think it's the member rightly reflects on and mentions the fact that we really do want to make sure that people are rehabilitated. So yes, in answer to that question, that is all taken into account under Bill C-5, and that would be one of the principal considerations that the minister would make.
Question.